Hello, I am Candace Gertis, a District Court Judge from the 2nd Judicial District. District Court Judge Paul King from Douglas County and Judge Mary Degenhart from the 7th Judicial District and I work together on the anatomy of a criminal trial. We know that demonstratives are a good way to keep your attention, so we dusted off the childhood game of Operation to help take you through the chapter. For each Operation game piece, you will have a brief outline of how it relates to a criminal trial and a practice note. So here we go. Starting with writer's cramp. When a person is charged with a crime, a charging document must be prepared that will recite the crimes charged and invoke the jurisdiction of the court. Such document may be a felony complaint to include a written statement of the essential facts constituting the offense charged, signed by the prosecutor and filed with the court, pursuant to Rule 3. Misdemeanors are charged by the filing of a summons and complaint. Upon the filing of a felony complaint, the prosecuting attorney shall request that the court issue a warrant for the arrest of the defendant, or a summons may be issued and served upon the defendant. If a warrant is requested, it must include sworn facts that establish probable cause that a criminal offense has been committed by the person for whom the warrant is requested. That is pursuant to Rule 4. When a defendant has been bound over to the trial court, the felony complaint is then deemed to be an information pursuant to Rule 7b-4. Now, as a practice note, in reality, charging documents will be fairly succinct, and the preparation will rarely result in writer's cramp. The funny bone. Defendants or the prosecution are entitled to request a preliminary hearing in cases involving qualifying felonies. Please refer to Chapter B for an in-depth discussion of this topic. The purpose of the preliminary hearing is to determine whether probable cause exists to believe that the offense charged were committed by the defendant. The request for a preliminary hearing must be made within 7 days after the first appearance and generally must be held within 35 days of the request. The burden of showing probable cause is on the prosecution. The rules of evidence may be tempered in the exercise of sound judicial discretion. See Rule 5. Now, please note you will not be harmed by presiding over a preliminary hearing, as it will not impact the funny bone, because it's not really a bone at all. We then move to the wishbone. The arraignment informs the defendant of the offense for which he or she is charged and requires the entry of a plea to the charge. A plea of not guilty will require that the matter be set for trial. A plea of guilty requires that the court make certain findings before accepting the guilty plea. Chapter I will discuss this in detail. Rarely are arraignments cut and dried. Instead, after arraignment, cases are often set over to allow the defendant an opportunity to have discussion with the prosecution regarding the possibility of a plea agreement. As a practice note, you are not required to have a supply of wishbones in your courtroom. The next piece is the Charlie horse. A request to continue a trial by the defendant carries a waiver of speedy trial. It might be prudent to inquire directly of the defendant if he or she understands this and is willing to waive speedy. A defendant must establish good cause in support of this request. The trial court must determine if the defendant will be prejudiced if the continuance is not granted, and should also consider whether the people would be prejudiced if the continuance is granted. For continuances requested by the defendant when he wants to change or she wants to change her counsel right before trial, there is an 11-point test that you must use found in People v. Brown at 322 P. 3rd 214. If the people request to continue the trial, the court should consider the prejudice to the people if not granted, and the prejudice to the defendant if granted. A trial continued at the request of the people should be set within speedy unless the defendant agrees to waive. A trial court may consider setting a trial outside of speedy at the request of the people if the evidence is unavailable and they have exercised due diligence in obtaining this evidence, and there are reasonable grounds to believe the evidence will be available at a later date. A trial court may also reset trial outside of speedy at the request of the defendant if extraordinary circumstances exist and the court makes specific findings. As a practice note, you may hear a request to continue at least once during a given case and even more than once on docket days. Drink lots of water and stretch before the docket day starts so the muscle cramping is not as severe in your Charlie horse. We then move to the brain freeze. There are 4 categories, just like the 4 lobes of the brain. Insanity is an affirmative defense that is to be raised at the time the plea is entered. It refers to the mental condition of the defendant at the time the crime is alleged to have occurred. The court can order the defendant to undergo an evaluation. The court must also conduct a lengthy advisement of the defendant, preferably both orally on the record and followed up in writing by the defendant signing the advisement, concerning the nature of the evaluation and the report that will be generated. Speedy trial is told during an insanity evaluation. Look to 16.8.101. Incompetence, the second lobe of the brain, refers to the present mental condition of the defendant. Competency can be raised by the defendant, the prosecution, or the court at any time. A person is incompetent if they cannot consult with counsel with a reasonable degree of rational understanding in order to assist in their defense. When competency is raised, the court must conduct an advisement of the defendant concerning the nature of the evaluation and a report that will be generated. Speedy trial is told during the competency evaluation. See 16.8.5.101. You can refer to Chapter F in this series for in-depth discussions of insanity and competency issues. If a party wishes to proceed pro se or without legal representation, the court must first conduct an advisement of the party pursuant to People v. Arguello. This is the third lobe of the brain. You should have the defendant complete a written advisement with initials and signature, followed by a full advisement orally on the record. If the party still wishes to proceed pro se after the advisement, the court is not required to assist, but must afford the party an opportunity to represent themselves as provided in the Sixth Amendment. Now, this is a difficult situation because most individuals will not be trained in the law and will want to represent themselves because they don't like what their attorney has told them about the legal assessment of the case. You may want to also briefly explain the trial process to make sure the defendant is aware of their obligations in selecting a jury, making opening statements, and examining witnesses. The fourth lobe is sovereign citizens. These individuals typically don't believe you have any authority whatsoever and will want to proceed without an attorney. You should also conduct an Arguello advisement, as I just outlined, before allowing the individual to proceed pro se. Then, be prepared for many filings and pleadings with questionable validity. When they have an audience in court, be prepared to listen to them discuss topics that are not relevant to the issues, and be prepared to firmly redirect their argument. It can be helpful to impose time limits on them and sustain objections that may be made should they not comply with court orders. We strongly suggest that you have your Tylenol or Advil ready in a Pez dispenser. We then move on to spare ribs. At the time a not guilty plea is entered, you may want to consider setting the matter for trial and a deadline for filing motions and a motions hearing date. Chapter E of this series discusses tips on setting deadlines. Most motions will be resolved at the hearing date, and many are stock, such as motions to suppress, child hearsay, and rape shield. Some of the motions may involve only argument, while others may require testimony. It is best to rule from the bench, as the defense will typically seek a transcript of the hearing before trial. You should also allow enough time between the motions hearing and trial for your reporter to prepare that transcript. It is important to resolve these motions in advance of trial. See chapters J and M on how to make findings and rulings. As a practice note, know your standards, who has the burden, and the stock case law so you are prepared to rule immediately at the close of the motions hearing. We then move to the trial, the first day of trial, where everyone has butterflies in the stomach, even the potential jurors. Please make sure to review your jury script in advance and have it updated to track with Colgy 2015 found on the judicial website. Your focus here should be to preside neutrally over the trial and put the jury and the attorneys at ease. Please put the jury at ease that their service is very important and you really value their appearance pursuant to their jury summons. Chapter N discusses in-depth jury selection. We suggest making jokes, even bad jokes, to get the jurors to relax and to talk about things, and everyone will feel less nervous. So the butterfly flies away. We then move to the Adam's apple. After the jury is selected, the prosecution makes their opening statement, followed by defense, which they can waive or wait until their case in chief. After opening statements, the prosecution goes forward with evidence, which can be witnesses and physical evidence. The attorneys and witnesses will have a lump in their throat, because they are ready to get the case to the jury, and thus the Adam's apple. It is important for you to make sure everyone is speaking slowly and clearly, not speaking over each other, and to watch the jury's attention span. This includes you too. Chapter P provides an in-depth coverage of this topic. We suggest you take the biggest gulp, so your Adam's apple will not be bulging when the jury comes in. The broken heart phase is twofold. One, for the jurors who are told they will not be deliberating, as they will likely be sad that they cannot deliberate after having listened to the evidence. The bailiff should escort the deliberating jurors and then excuse the non-deliberating jurors and read them the mandatory discharge instruction. It might be a nice touch to let the excused jurors know that prior to selection, a seat was chosen so that they understand that they had nothing to do with them being the alternate. You can also offer to call them with the results of the deliberations. The other phase of the broken heart will be the wait game, deliberations, and the reading of the verdict. As for deliberations, be prepared for questions from the jury, which should always be in writing, and the defendant as well as counsel should be present for the making of the record. Even when your defense counsel says, "Oh, we'll waive our client's appearance," the answer you should give is no. The answer to be given to the jury should be in writing as well. When the jury has notified the bailiff that they have a verdict, make sure everyone is in place in the courtroom before bringing the jury into the courtroom. Also, make sure that all safety procedures are followed and you have a sufficient number of deputies present in case people react to the reading of the verdict. Once the jury is in the courtroom, check to make sure the instructions and verdict forms are proper, and then read the verdict in open court. After the jury is polled, then read the mandatory discharge instruction and ask the jury to return to the deliberation room so that you may speak to them briefly. As a practice note, some charges may carry an automatic remand after conviction. Please be sure you know the answer in advance, and you can refer to Chapter P of this series for an in-depth discussion. Finally, we come to the wretched ankle. This is sentencing. You should have an outline of what comments you want to make and then be prepared to incorporate those into your comments after the sentencing has been heard by both parties. The findings should be clear and concise as to each count. Chapter Q provides a detailed outline of this topic. The best advice is that of former Chief Judge from Denver, Jeffrey Bayless, who said, "What you don't say, you don't have to explain." Now, as a practice note, and on a serious note, there is no easy or quick remedy for the healing from a sentencing. Just like a sports injury, it takes time to recover from the tough decisions that you had to make. My thanks to my co-faculty, Judge King and Judge Dagenhart, to Mel Room for making the cutouts for the game pieces, and to my parents for never throwing anything away so I could bring my childhood game to good use.